Imagine this. A covert investigation. It's all happening hush-hush. Then bam, a raid. Police storm in.
Yeah.
They find heaps of cash, hidden guns, and all these bags of, like, white powder disguised as just washing powder.
Standard laundry, supposedly.
And right in the thick of it, a father and son. Sounds like the start of a pretty intense true crime movie, doesn't it?
It absolutely does. You've got the alleged syndicate, the secret surveillance, the big reveal of all the illegal stuff.
But the real twist here, the thing that makes the story so fascinating, isn't just about if they committed the crimes. It's about the system itself.
Exactly. It shifts focus. It becomes about how we try to catch criminals, the power we give to law enforcement, and whether a really fundamental principle of justice got trampled in the process.
Right. Did the push to get a conviction end up undermining the very idea of a fair trial?
That's the core question.
So that's what we're doing today. This isn't just recounting a crime story. It's a proper deep dive into a massive legal case, Lee v. the Queen. We've got the court documents, the judgments, the expert commentary.
All the sources.
And our mission is to unpack it all. We'll meet the people involved, follow the timeline from the very start, see how this secret weapon the prosecution got hold of totally changed things in Australia, and figure out the lasting impact.
Yeah, we'll trace it right from those compelled crime commission interviews through the raid, the jury trial, the first appeal where they lost, and then all the way up to the high court, where the really big principles were fought over. It tells you a lot about that, well, sometimes tricky relationship between fighting crime and protecting rights.
Okay, let's get into it. Who are the key players in this drama? All right, like any big story, this one has its cast of characters, and the stakes couldn't have been higher. Their decisions really drove the whole thing.
Absolutely. And right at the center, obviously, are the two men who were charged, convicted, and then fought those convictions all the way, the appellants.
First, there's the father, Do-Young Lee, known as Jason. The sources describe him as a Korean-Australian father, and interestingly, his first brush with the law that put him on the radar wasn't even directly related to the main drug charges.
No, that was back in February 2009. He was facing charges over quite a bit of cash, $95,000, plus casino chips worth $175,000, and some drugs and stolen goods, apparently. Those charges were just sort of pending.
But it definitely flagged him for the authorities.
Oh, for sure. Especially the NSW Crime Commission. He became a major target for their investigation, and that led to the really serious charges: importing commercial quantities of pseudoephedrine, illegal firearms, and money laundering.
And the crucial part for this story, he was compelled to testify.
Yes, absolutely pivotal. He was legally forced under oath to answer questions of the Crime Commission. If he refused, he could face jail time just for that.
Wow.
And his whole appeal, his whole fight later on, was based on the argument that the prosecution improperly got hold of that compelled testimony and used it against him at his trial, that it poisoned the well.
Okay, and then there's his son, Seong Won Lee.
Right, Jason's son. He was actually there when the police raided the place. He ended up facing charges 2 firearms, and then specifically being knowingly concerned in his father's alleged drug supply.
And like his dad, he was also forced to testify.
Yes, he was also summoned for one of these compulsory examinations at the Crime Commission. The sources suggest he was probably, in his 20s at the time. You can imagine how intimidating that must have been.
Definitely. In the hot seat, as they say.
Yeah, forced to answer potentially incriminating questions. And his appeal, just like his father's, argued his conviction couldn't stand because the prosecution had seen the statements he was forced to make.
So you've got the father and son facing these massive charges, and this compelled evidence becomes the central legal battleground. Who was guiding them legally through all this? It sounds like a long, tough fight.
It was incredibly long. Their solicitor, the lawyer managing the case from the ground up, was Dennis Morales from the firm Nyman Gibson Stewart. He was with them consistently throughout the entire process.
And his role was key.
Absolutely critical. Not just preparing the appeals, but he was the one who actually dug in and uncovered the crucial details about how those supposedly secret crime commission transcripts ended up with the prosecution. Finding that email chain was a game changer.
Right, the smoking gun, so to speak. And who are the barristers arguing the case in court?
Well, for the initial trial, given how serious the charges were, they would have had experienced barristers, almost certainly senior counsel, or SC, that's the top rank for barristers in Australia.
Makes sense.
As the case went up through the appeal courts, they briefed even more prominent SCs. Their job was huge. Convince the judges that a fundamental injustice occurred because the prosecution had been, as the High Court later said, armed with this compelled evidence.
Do we know the names?
Yes, the High Court judgment lists them. For Jason Lee, it was Murugan Thangaraj SC leading G.A. Bashir. For Seong Won Lee, it was T.A. Game SC leading S.S. Parashasingham, both teams instructed by Dennis Morales' firm.
And earlier on.
Earlier, at that crucial pre-trial hearing, where this transcript issue first surfaced, Mr. Sutherland SC appeared for Jason Lee. And at the actual trial, Sean Grant represented Seong Won Lee. So a strong team adapting as the case moved up.
That's a serious defense lineup. What about the other side, the prosecution?
Representing the Crown, which is formally the Queen in these cases, at the High Court level, were Natalie Adams, SC, Joanna Davidson, and Helen Roberts. They were instructed by the state's solicitor for public prosecutions.
And who actually asked for the transcripts?
The sources point to a specific DPP solicitor back in July 2010. We don't have their name, but their email request is a central piece of the puzzle. And then there's the prosecutor who actually ran the trial, Michael Barr. He later gave evidence about reading the transcripts.
What did he say about them?
He admitted finding them interesting and informative, saying they gave him insight into potential defenses. But he also said he thought it seemed unusual to get them, though he didn't question it further at the time.
Unusual. That feels like an understatement given what we know now.
It does, doesn't it? It highlights the ethical gray area, or maybe not so gray area, they stepped into.
And we can't forget the Crime Commission officials in the background.
No, their role is crucial, even if indirect in the courtroom. Philip D. Bradley was the commissioner back in 2009-2010. He had these immense statutory powers, including compelling testimony.
And he approved the release.
Yes, that's the critical step. He marked the DPP's email request approved. That action authorized the release of the secret transcripts, breaking the commission's own rules, and the law designed to protect fair trial rights.
So the system designed to compel evidence also failed to protect it.
Essentially, yes. The officials responsible for safeguarding that evidence under a specific legal order allowed it to be disseminated improperly. That failure is what sparked the whole legal drama. We don't know the names of the counsel assisting who did the questioning, but the commission's handling of the output was the problem.
And there was a key witness for the Crown, too.
Right, Brendan Pack, described as a former associate involved in the same washing powder scheme. Interestingly, he also gave compelled evidence to the Crime Commission.
Like the Lees.
Exactly. But he later became a key prosecution witness against them, presumably after making some kind of deal. His testimony was important for the Crown's case. The fact he was also compelled adds another layer of complexity to how this information was handled.
Finally, the judges who had to make sense of all this at different stages.
Well, you start with the trial judge in the district court. They ran the jury trial, heard the evidence, passed sentence. But crucially, they didn't know during the trial that the prosecution had these transcripts. That only came out properly later.
Then the appeal.
The first appeal went to the NSW Court of Criminal Appeal, the CCA. The judges there were Justice Baston, Justice Hall, and Justice Beach Jones. Justice Basson wrote the judgment that actually dismissed their appeal.
And finally, the top court.
The High Court of Australia. 5 justices heard the final appeal. Chief Justice French, Justice Crennan, Justice Kiefel, Justice Bell, and Justice Keene. Their unanimous decision turned everything around.
Okay, so that's the lineup. The accused, their lawyers, the prosecutors, the officials, the witness, the judges. Everyone played a part in a case that ultimately tested the foundations of the justice system.
Right. Let's wind back. Late 2009, Sydney. We need to understand how this all kicked off with Operation Swansea.
Yeah. Operation Swansea was the NSW Crime Commission's code name for this pretty major covert investigation they were running. They were targeting what they believed was an organized group importing pseudoephedrine.
Which is used to make meth, right?
Exactly. And the allegation was it was being smuggled in disguised as or hidden within laundry powder. So big-scale stuff, possibly linked to cash, guns, other drugs.
And Jason Lee was already on the radar because of that earlier incident with the cash and casino chips. That definitely seems to have put him in the spotlight. That was back in February 2009. So when Operation Swansea formally started targeting him, his son Seong Won, and Brendan Pak in August 2009, the authorities already had some interest in his activities. The net was tightening.
And this is when the Crime Commission uses its big power play of the compulsory examinations.
This is where it gets really different from a standard police investigation. Under the law back then, the NSW Crime Commission Act 1985, the commission had these extraordinary powers. They could force people into secret hearings, make them swear an oath, and compel them to answer questions.
You couldn't plead the fifth, basically. No right to silence.
Not in the same way as in a police interview. Refusing to answer or lying under oath could land you in serious trouble, even jail for contempt. It's a powerful investigative tool.
And Jason Lee went through this.
He did, twice. November 26th and December 1st, 2009. You have to picture him, sworn in, facing intensive questioning from the commission's lawyers. They'd be digging into everything. Where did the money come from? Did he know about chemicals?
Yeah.
Who were his associates?
And every word recorded.
Every single word. Transcribed. Creating a permanent record of testimony he was legally forced to give.
But wasn't there supposed to be some protection? You can't just force someone to incriminate themselves and then use it against them in court, surely.
That's exactly right. And the law did provide for protection. Section 13, subsection 9 of the Act gave the commissioner the power to order that this compelled evidence could not be published or given to anyone, specifically including police or the DPP, if it might prejudice a future trial.
And did the commissioner make that order for Jason Lee?
Yes, he did. Commissioner Philip Bradley explicitly made that direction. Its entire point, the reason it existed in the law, was protect Jason's right to a fair trial later on. To stop the prosecution getting a sneak peek at what he was forced to say. It's fundamental the state has to build its own case, not force the accused to help them.
So that testimony was meant to be locked away, kept separate from the criminal case. What about Seong Won? He was examined too.
Yes. His examination was a bit later, early 2010. The powder they'd seized was still being tested at the lab. He faced similar questioning, likely very nervous. The sources say he was asked about the white powder and denied knowing it was anything illegal, claiming he thought it was just washing powder.
Was his testimony protected too?
Well, the records show a formal S-13 direction wasn't made right at that moment. However, later in court, the Crown accepted that one should have been made, given charges were likely. So effectively, his testimony was treated as being covered by the same confidentiality rule for the same reason fair trial rights.
Okay, so Jason finishes his second examination on December 1st, and then just days later, the raid happens.
It was fast, December 7th, 2009. Acting probably on intelligence gathered during the investigation, including maybe from those examinations, NSW police execute a search warrant. And it was dramatic.
What did they find?
A lot. Hidden inside the premises were guns, a revolver, even a submachine gun. Plus, all those bags of white powder packed like laundry detergent. And cash. A huge amount, over $1.1 million. They also found documents in Korean that seemed to link the Lees to the stash.
So the powder gets sent off for testing immediately?
Yeah, urgent forensic analysis. Strong suspicion it was pseudoephedrine.
And arrests follow straight away.
Same day as the raid. Jason and Seong Won Lee are arrested. Initially, they're charged with the firearms offenses. Jason also gets hit with a charge related to that massive pile of cash first as goods in custody, later upgraded to money laundering.
But not the drug charges yet.
Not yet. They needed the lab results to confirm what the powder was. At this stage, the sources say both father and son denied knowing the items were illegal, sticking to the "it's just washing powder" line for the powder itself.
But those lab results were inevitable, really.
Very much. By mid-2010, the analysis comes back. It is pseudoephedrine and a commercial quantity, which is the most serious level under the law. That confirmation changed everything.
So more charges filed?
Yes. Serious drug supply charges were added against both Jason and Seong Won. Now, you had the full picture. Major drug charges, firearms, money laundering, everything was set for a joint trial. But behind the scenes, something was about to happen that would fundamentally undermine the whole process.
Okay, so the trial is looming, all the pieces seem to be in place, but this is where the story takes that really critical, illegal turn.
This is the moment that protective shield, that S-13 order designed to keep the compelled testimony separate, was breached. Unlawfully breached.
How exactly did that happen? How did the protection fail?
The sources are quite specific. In July 2010, a solicitor working at the DPP's office, handling the Lee case, sends an email. It's addressed to the police officer who actually laid the charges.
And what did the email say?
It was a direct request for the transcripts of Jason and Seong Won Lee's compulsory examinations at the Crime Commission. And the reason given is incredibly telling. The solicitor wrote they wanted them, quote, especially if it is something the defense are going to try and rely on specifically that they had no knowledge.
Wow. So they explicitly asked for the secret testimony to figure out the defense strategy.
That's exactly what it looks like. It wasn't accidental. It was a deliberate attempt to get hold of compelled evidence to anticipate and counter the defense case.
And the Crime Commission, which was meant to be guarding this information, just handed it over.
This is the crucial failure. The request went to Commissioner Philip Bradley, and he approved it. He literally marked the request approved.
Despite his own secrecy order.
Despite the S-13 order being in place specifically to prevent this, his approval authorized the unlawful release of those transcripts containing the Lee's forced answers about cash, chemicals, their denials directly to the police and the prosecution team.
Unbelievable. And it wasn't just the transcripts, was it? Other compelled material got shared, too.
That's right. Documents Jason Lee had been forced to produce during his examination, maybe documents explaining the source of all that cash, were also shared. The Crime Commission apparently used these compelled documents to take statements from other people connected to them.
Like potential witnesses.
Exactly. People named Choi, Jang, Park, and others. And those statements, with Jason's compelled documents attached, were then given to the police for the money laundering investigation.
Even though similar documents might have been found legally in the raid.
Yes, the sources mention identical documents were found in the police search too. But sharing the versions, obtained via compulsion, attached to commission statements, just further blurred the lines and potentially gave the prosecution insights derived directly from that coercive process.
The sources use pretty strong language about why this was wrong.
They do. They say the decision to release the transcripts and documents was made without regard for the whole protective point of S-13, protecting fair trial rights, and releasing them to the DPP was for a patently improper purpose, finding out the defense case in advance.
So it wasn't just a bureaucratic slip-up, it was seen as a deliberate, tactical move.
That's the implication. Aimed at gaining an unfair advantage by accessing information the defense was legally forced to give up in a completely separate, non-criminal setting.
So, armed with this secret information, the prosecution prepares for trial. The trial itself kicks off when?
It was initially listed for November 2010, but actually started in January 2011. Interestingly, it was a different prosecutor, Michael Barr, who ran the trial, not the solicitor who originally asked for the transcripts.
And when did the defense find out the prosecution had seen these secret statements?
That happened at a pre-trial hearing, November 23, 2010. The Crown prosecutor, Mr. Barr, actually mentioned in court that he'd read the compelled testimony and might use evidence to counter explanations the Lees had given under compulsion.
He just said it in open court.
Apparently so. This was the first time the defense lawyers present realized the prosecution had seen the transcripts. They had actually been served as part of the brief back in October, but maybe buried in the paperwork. Jason Lee's senior counsel at that hearing, Mr. Sutherland S.C., immediately voiced significant concern, according to the court records. He knew straight away this was a major problem.
I bet. That must have set off alarm bells everywhere for the defense.
Absolutely. This discovery planted the seed for the appeals later on. At this pre-trial stage, the defense did raise issues. The money laundering charge got severed, set aside to be dealt with separately.
Okay.
But the judge ruled the evidence of the $1.1 million cash was still admissible in the main drugs and firearms trial. The judge thought it could suggest drug dealing or was just part of the overall picture.
Which the defense would have hated, right? That's the money they might have explained under compulsion.
Exactly. The defense argued against it, saying it brought the money issue right back in, and hinted they might have to reveal the explanation for the cash they'd given the Crime Commission.
So how did this affect their strategy in the actual trial?
It clearly shaped it. Their main defense was lack of knowledge. Jason Lee argued the money wasn't drug money, and he didn't know the powder was pseudoephedrine. Maybe someone else put the boxes there. Seong Won kept saying he genuinely thought it was just washing powder.
And they attacked the main witness.
Heavily. They went after Brendan Pack's credibility, calling him a self-confessed liar, a perjurer, pointing out inconsistencies, including in things he'd said under compulsion himself at the commission.
Did Jason Lee testify at the trial?
No, he didn't. And his solicitor later suggested that knowing the prosecution had read his compelled statements essentially made it impossible for him to take the stand. It was too dangerous.
Because the prosecution knew exactly where to trip him up. This invisible script idea.
Precisely. The prosecution had this unfair advantage. They knew the denials, the explanations Jason and Seong Won had given when forced to speak. It allowed them to tailor their cross-examination, to anticipate answers, to probe weaknesses based on that compelled testimony.
Sharp and calculated, the sources said.
Yes. When Seong Won denied knowing about the powder, the prosecutor could ask questions informed by his secret compelled statement. And Mr. Barr, the prosecutor, later admitted under oath at the appeal court that having the transcripts was interesting and informative, gave him insight into the defense case, even if he felt it was unusual.
And the jury deciding their fate knew nothing about this background advantage.
Absolutely nothing. They just saw the trial unfold, the evidence, the questioning, the arguments. They had no idea the prosecution might be following a hidden script, using information the Lees were forced to provide under supposedly protected circumstances. It created a fundamental imbalance, invisible to the decision-makers.
So the trial concludes. What was the verdict?
In March 2011, the jury came back. Jason Lee was found guilty of supplying drugs, 2 counts, and possessing a prohibited firearm. Seong Won Lee was found not guilty of the main supply charge, but guilty of the lesser charge of being knowingly concerned in his father's supply, plus 4 counts of possessing firearms.
So convictions across the board on serious charges.
Yes. Despite the defense efforts, and with the prosecution armed with that secret knowledge, both men were convicted and faced significant jail time.
Convicted, sentenced. But for the Lees and their legal team, especially knowing about those transcripts, this clearly wasn't the end. The appeal process begins.
Straight away, pretty much. Jason and Seong Won Lee appealed their convictions to the NSW Court of Criminal Appeal, CCA. By this point, their lawyers, Dennis Morales and the barristers, were fully aware the prosecution had obtained and read the compelled transcripts before the trial.
They knew the what, but maybe not the full how or the significance initially?
Perhaps not the full picture immediately, but as they dug into preparing the appeal, and especially after Morales found that crucial email trail showing the DPP's request and the commissioner's approval,
It all became crystal clear.
devastatingly clear. The direct request, the unlawful approval, the blatant breach of the S-13 order. This became the absolute cornerstone of their appeal. They argued this wasn't just a minor error, it was a fundamental miscarriage of justice that meant the convictions had to be thrown out.
That's a huge claim. How did the Crown respond at the CCA? This is where things got interesting, right?
Very interesting. Initially, in their written arguments filed with the court, the Crown actually conceded a major part of the Lee's case.
They admitted they were wrong.
They admitted the release of the transcripts to the DPP was unlawful, a breach of S-13-9, and based on that unlawful act, they went even further and conceded that the trial had miscarried, at least regarding the drug charges.
Wow. So the prosecution itself initially agreed the trial was flawed for the main charges.
That was their initial written stance, yes. But they didn't make the same concession for the weapons charges. However, when it came to the actual court hearing, the CCA judges apparently pushed back, expressing doubts about just accepting this concession for the drug charges.
As the Crown changed its mind.
They did. They partially withdrew their position during the oral arguments. They stuck to the admission that releasing the transcripts was unlawful, but they retracted the concession that this automatically meant the drug convictions resulted from a miscarriage of justice.
What was their argument then?
They shifted tack. They argued the legal test for a miscarriage should be the same for both drug and weapons counts, and that the court should apply the proviso.
The proviso. What's that?
It's a legal escape hatch, basically. Even if there was an error in the trial, an appeal court can still uphold the conviction if they're convinced that no substantial miscarriage of justice actually happened because of that error. In other words, the outcome would likely have been the same anyway.
So they admitted the illegal act, but argued it didn't really cause enough harm to overturn the result. How did the CCA judges rule in the end?
In April 2013, the CCA justices Baston, Hall, and Beach-Jones dismissed the appeals. Their decision really came down to what they called the practical unfairness test.
Practical unfairness.
Yeah, their logic was, just because the prosecution had material they shouldn't have had, the transcripts weren't shown to the jury, remember, doesn't automatically make the trial unfair. They looked for hard evidence of unfairness in how the trial actually ran.
Like, did the prosecutor ask improper questions based on the transcripts? Did the defense get shut down?
Exactly. And they concluded they couldn't find objective proof of that kind of unfairness directly flowing from the transcript use. They also pointed out something else significant.
What was that?
They noted that the defense team knew the prosecution had the transcripts before the trial started from that pretrial hearing. But they didn't formally object then or try to get the trial stopped permanently, a stay of proceedings.
And the CCA interpreted that as?
They inferred that maybe even the experienced defense lawyers at the time didn't see it as causing such a definite irreparable disadvantage that the trial couldn't go ahead.
So the CCA's bottom line was, yes, getting the transcripts was illegal and wrong, but looking at how the trial played out, we can't see proof it actually made a real difference or prejudiced the Lees enough to count as a miscarriage of justice.
That's pretty much it. They found no practical unfairness that materially prejudiced the Lees to the point where the jury's verdict should be overturned. So the conviction stood. Jason and Seong Won Lee lost their first appeal.
Ouch. A huge setback, especially after confirming the prosecution acted unlawfully.
Massive. The CCA essentially said the breach, while real, didn't meet the threshold for causing demonstrable harm in the courtroom itself.
Yep.
But for the defense, this missed the bigger picture, the fundamental compromise of the process itself. And that set the stage for the ultimate showdown.
So the Court of Criminal Appeal says no practical unfairness convictions stand. But Jason and Seong Won Lee and their determined legal team, led by Dennis Morales, weren't giving up. It's off to the High Court of Australia.
The final appeal, their last shot. This is in May 2014.
Oh.
And they had heavy hitters arguing for them now. Murugan Thangaraj SC and G.A. Bashir for Jason, T.A. Game SC and S.S. Parajasingham for Seong Won. Still instructed by Nyman Gibson Stewart.
Not facing them.
The Crown team was led by Natalie Adams SC with Joanna Davidson and Helen Roberts.
What was the core argument the Lee's team put to the High Court justices? It couldn't just be practical unfairness again.
No, they went right back to basics, to the fundamental principles. They argued the CCA used the wrong test entirely. Their point wasn't about proving a specific dodgy question in cross-examination. It was that the mere fact the prosecution was, in the High Court's eventual words, armed with the evidence of the accused obtained under compulsion, was itself a violation of what a fair trial means in our system.
So the very possession of that compelled evidence tainted the trial, regardless of how it was used.
Exactly. They argued the right to silence, the right to a fair trial, are so fundamental that any significant breach like this, even if you can't precisely measure its impact, is a miscarriage of justice by its very nature. The CCA's focus on finding tangible prejudice in the trial record was too narrow, they said. It ignored the breach of a fundamental presupposition of the accusatorial system.
The reports mentioned the High Court judges asked some pretty searching questions during the hearing. That must have given a clue.
Oh, definitely. The justices clearly weren't buying the Crown's argument that no proven practical unfairness was the end of the story. Justice Bell, in particular, asked that killer question. On what basis can it ever be fair for the Crown to know the compelled testimony of the accused, when the jury cannot and the defense cannot know what use you made of it?
That really cuts to the chase, doesn't it? The information asymmetry.
It perfectly captures the inherent, unquantifiable unfairness. And the Crown lawyers, essentially sticking to the CCA's reasoning, struggled to give a convincing answer beyond repeating that no specific negative impact on the trial's conduct had been demonstrated.
And Justice Kiefel brought up the idea of justice needing to be seen to be done.
Yes, a crucial point. She observed that the integrity of the judicial process must be maintained not only in fact, but in appearance. That implies that even the risk of unfair advantage, the mere appearance that the prosecution had improper access, can damage public confidence in the whole system.
Right.
Protecting the core principles is vital for legitimacy.
So, the arguments are heard, the questions are asked. Then comes the judgment.
May 21st, 2014. And it was unanimous. All 5 High Court justices agreed. The decision was a bombshell. Appeals allowed. CCA decision overturned. Convictions of both Jason and Seong Won Lee were quashed. New trial ordered.
Wow. And their reasoning, why did they completely disagree with the CCA?
Their reasoning was powerful and reset the benchmark. They found the trial the Lees received differed in a fundamental respect from that which our criminal justice system seeks to provide. And that fundamental difference, in itself, was the miscarriage of justice.
They focused on that secrecy rule, S13-9.
Heavily. They said its whole purpose was precisely to stop this scenario, to uphold the common law principle that the prosecution has to prove its case on its own without relying on evidence forced out of the accused.
They used very strong words to describe that principle.
Incredibly strong. This quote is now famous in Australian law. It is a breach of the principle of the common law and a departure in a fundamental respect from a criminal trial, which the system of criminal justice requires an accused person to have, for the prosecution to be armed with the evidence of an accused person obtained under compulsion concerning matters the subject of the charges.
So just being armed of it was the breach, not necessarily using it in a specific way?
That's the core finding. They weren't concerned with whether the prosecutor definitely used line X from the transcript to ask question Y. They said the mere fact the prosecution possessed this compelled information about the case, information they got through coercion, was enough to fundamentally flaw the trial.
And they explicitly threw out the CCA's practical unfairness test.
Explicitly rejected it. They said that test was too narrow and missed the fundamental nature of the violation. The possession of the compelled evidence by the DPP put the fairness of the trial at risk right from the start. It created an unacceptable imbalance. You don't need to prove exactly how things might have gone differently. The process itself was contaminated. The well was poisoned, essentially.
So, after all those years, conviction's gone, based on this fundamental principle.
That's it. Convictions for drug supply, firearms, knowingly concerned, all quashed for both father and son. A new trial was ordered, although the High Court judgment did hint that running a retrial might be problematic given the history and the time elapsed. But in that moment, it was a huge victory for the Lees and their legal team, vindicating their fight on a core principle of justice.
So the High Court decision wasn't just about Jason and Seong Won Lee. It sent ripples through the entire Australian legal system. What's the real legacy of Lee v. the Queen?
It's seen as a landmark case, absolutely. Legal experts immediately recognized it as a major reaffirmation of the integrity of our accusatorial trial system. The idea that the prosecution proves its case, the accused doesn't have to help them.
What did commentators say?
Well, the Rule of Law Institute called it a formidable judgment. They loved that quote about the prosecution being armed with compelled evidence being a breach of common law. They saw it as the High Court saying, no, you can't just sweep these fundamental breaches under the carpet because proving the exact impact is hard.
It sounds like it put everyone on notice, investigators, prosecutors.
Definitely. Professor Jeremy Gans made the point that the High Court really shifted the focus towards institutional integrity. It's less about trying to guess if the trial outcome might have changed, and more about keeping the process itself pure and fair. He even called compelled evidence like this toxic for prosecutors.
Toxic?
Yeah, basically saying if you, as a prosecutor or police, improperly touch this kind of compelled material relating to the charges, you risk blowing up your whole case, no matter how strong the other evidence is.
So a massive warning sign for how prosecutors do their jobs.
Huge impact on prosecutorial conduct and ethics. The High Court reinforced that the prosecutor's job isn't just winning, it's ensuring a fair process. After Lee, any prosecutor actively trying to get hold of an accused person's compelled testimony for the case they're running would be seen as committing serious misconduct.
It became a training example.
A major cautionary tale in DPP training across Australia. The message is clear. Trying to grab a short-term tactical advantage by using improperly obtained information can destroy years of investigation and the entire prosecution. Fairness comes first, even before securing a conviction.
Did the actual laws change because of this?
Yes, tangibly. The specific law involved, the old NSW Crime Commission Act 1985, was repealed. The new Crime Commission Act 2012 came in, and it includes Section 45, which essentially carries forward those confidentiality rules, arguably strengthening them.
So Lee made legislators think harder about these powers.
Absolutely. It served notice that if Parliament gives bodies coercive powers, it must build in clear, strong safeguards for fair trial rights. The High Court's focus on the purpose of the old secrecy rule showed courts will interpret these powers narrowly to protect fundamental rights, unless Parliament is incredibly explicit. Otherwise, that's the principle of legality.
So new laws creating similar bodies have to be more careful now.
Definitely. Any new laws setting up commissions or integrity bodies with powers to compel evidence now usually include very specific rules about how that information can, and more importantly cannot, be shared with prosecutors. Lee showed the danger zone you enter if you don't have those clear lines.
What about the Crime Commission itself? Did it change how they operate?
It certainly prompted reflection. The case, as one commentator put it, slightly dented their image by revealing a failure to stick to the legal limits on their own evidence. They reportedly reviewed their internal policies on handling examination material to stop it happening again.
More coordination now.
Seems so. Better protocols between the Commission and the DPP to make sure compelled testimony isn't shared improperly, usually only allowing it in very specific, legally defined situations, like for totally unrelated investigations, or maybe after the original case is completely finished.
And did it feed into wider debates?
Yes, it was mentioned in the long-running discussions about setting up a federal anti-corruption body, which we now have with the NACC. Lee served as a reminder that any such powerful body needs strict separation between its coercive investigations and any criminal prosecution process.
And finally, how does Lee get used in court now? Does it influence other cases?
It's cited all the time. It's become a key authority on trial fairness, especially when issues about compelled evidence or prosecution knowledge arise. Cases like Roberts v. the Queen from 2020 refer back to Lee to support the idea that fairness isn't just about admitted evidence, but also about ensuring the prosecution doesn't have an illicit advantage. It reinforces related ideas too, like the right to silence. It's a modern cornerstone case on these issues.
So, quite a journey. From that raid in Sydney uncovering cash and powder, all the way to a high court ruling that reshaped a fundamental part of Australian justice. Hashtag outro. And that wraps up our deep dive into Lee v. the Queen. It's a case that really underscores something vital about our justice system, isn't it? It's not just about finding out who did what, it's fundamentally about how we find out.
Exactly. The High Court didn't just correct a mistake, they sent a powerful message about a core principle.
Mm.
The state has to prove its case against you fair and square, using its own efforts, not by forcing you to hand over the ammunition they used to convict you.
It really highlights that constant tension, that balancing act. We give investigators strong powers to fight serious crime, which seems necessary, but Lee shows how crucial it is to have strict guardrails around those powers to protect individual rights, especially the right to a fair trial.
It's a balance that needs constant vigilance.
Yeah. And it leaves us with a big question to chew on, doesn't it? Where do you draw that line? Between the state's need to investigate crime effectively and the individual's right to face charges on a level playing field. What does fair really mean when one side gets a secret look at the other side's compelled statements, even if they don't waive those statements in front of the jury?
It's a question that doesn't have easy answers, especially as investigations get more complex. Something definitely worth thinking about.
Indeed. Thanks for joining us for this exploration of a complex, challenging, and incredibly important legal battle.